I'd like to welcome everyone at the Indian Union Debate Forum. I'll introduce our speakers once they take the stage. Before that, I'd just like to explain the rules. Each speaker will get 10 minutes. We will alternate between one speaker who will speak for the proposition and one against. We have taken a vote of the House of which way they believe, are they for the proposition or against before the debate, and we will follow this up with a vote at the end of the debate to find out who has been more persuasive. So before we start, could I please request all the speakers to take the stage, please? Thank you. So while the speakers take their positions, the debate number 2 at the Indian Union Debate Forum, the proposition is, this House will establish the National Judicial Appointments Commission, abolishing the collegium system. Those who will speak for the proposition are Pinky Anand. Dr. Anand is a senior advocate at the Supreme Court of India and has been serving as the Additional Solicitor General for the Government of India since 2014. Dr. Anand is the All India in charge of the legal cell of the BJP and member of the All India National Executive of the Bharatiya Janata Party. She represents the party at various levels and is also a member of the governing body of the Bar Association of India. She is a recipient of the French National Order of Merit by the President of the French Republic. Welcome, Dr. Anand. The second speaker who will speak for the proposition is Mr. KTS Tulsi. He is a senior advocate and former Additional Solicitor General of India. Mr. Tulsi has been serving as the President of the Criminal Justice Society of India since 1994. In the same year, he was elected the President of the Intellectual Property Attorneys Association and later as its Vice President. Later as the Vice President of the Asian Patent Attorneys Association. Welcome, Mr. Tulsi. The third speaker who will speak for the proposition is Isha Jain. Isha is presently in her third year studying LLB Honours BA at the National Law School of India University, Bangalore. She is an acclaimed debater in the national and international circuit and has a keen interest in moot courts. Welcome, Isha. Those opposing the proposition are Ira Regmi. Ira is an LSR grad. She is the winner of the Trinity British Parliamentary Chambers debate in Dublin. She won the Model United Nations at Harvard, and she was invited to judge the World's University Debating Championship, and she's a copy editor at Akado. Is that correct? Okay, Akado. Welcome, Ira. Our second speaker who will be opposing the proposition is Akash Patnaik. Akash is in his final year studying economics at the Sriram College of Commerce, Delhi University. Akash was a joint secretary of the SRCC Debating Society. He has won several national debates in India. He is also currently working with the Energy Resource Institute. Welcome. And our final speaker who will be opposing the proposition is Mr. Biswajit Bhattacharya. Mr. Bhattacharya is a senior advocate, a teacher, a banker, and an author. He's a gold medalist from Delhi University. He is a visiting professor at IIM Ahmedabad and visiting faculty at the Indian Law Institute. He has also served as the Additional Solicitor General in India. Most recently, he was the petitioner for the landmark NJAC case in which the Supreme Court of India declared the NJAC unconstitutional. Welcome, Mr. Bhattacharya. Before we start, I would just like to request all speakers to adhere to the time limit of 10 minutes. I will alert the speaker at the end of the 9th minute and be forced to interrupt at the end of the 10th. With that, let's start. The proposition being, this House will establish the National Judicial Appointments Commission, abolishing the collegium system. Our first speaker for the proposition is Dr. Pinky Anand.
Thank you. I must say at the outset, I know this is not part of the debate, but I'm frightened by the number of speakers and their eligibility and their criteria. I'm used to being on the other side and judging the debate, so I'm equally frightened being this side. However, we survive in this kind of situation. The proposition, it's also easier to be on the opposition, because then you have the first speaker speak first and then you kind of break them down one by one, piece by piece. But since it's for me to establish the proposition, where do we start? We can go back to the constitutional setup. Whether it should be under the Constitution, whether it is valid under the Constitution, whether the judgment is something which needs to be criticized, analyzed, discussed. The second part, I guess, would be ultimately taking it from the perspective of the people. What do the people need? What does the justice system need to deliver? And I think these are the two broad parameters on which you can judge whether the NJAC is valid, is needed. I would go beyond validity to say needed, is a need of the hour, or whether it is not. So ultimately here goes the question on the Constitution. And since all of you are lawyers at one level or the other, and I believe most of you are from the law schools, the national law schools, extremely well qualified and eligible to judge this issue. Here we go. We have the Constitution which says in terms that the executive will appoint the judges, the superior judges. You have consultation with the Chief Justice of India. That is Article 124 for you. And you have similarly for the High Court appointments. Then we go down history lane. We go down to firstly Shamsher Singh, which established that the executive will appoint. But then we started having a different discourse. And the discourse brings out the following feature, which if you analyze it, how does it stand valid? How can consultation mean mandate? How can consultation mean something which must be complied with? How does consultation in any manner of either language or law take the factum that there should be not only primacy, but literally exclusivity of the Chief Justice of India, in addition to then subsequently making out something which is called a collegium system, which never existed in the Constitution. All of us believe that our allegiance to the Constitution, our desire to adhere to the tenets of the Constitution, the preamble, the contents, the structuring, the basic structure of the Constitution, would really be militating against any other interpretation. Consultation meant ultimately you had a role, the Chief Justice had a role in the entire discussion. Dr. Ambedkar, who made the Constitution, gave only that role, and that is the manner it is for the courts to interpret what is there in the Constitution, but interpretation cannot be an evolution of a theory which is totally destructive of the basic tenets of the Constitution, or against the mandate of the Constitution, which said it is the power of the executive to appoint. Having said that, you had Shamsher Singh saying executive has primacy. The first judge's case went on to say the consultation should be meaningful. The second judge's case went much further and said whatever the Chief Justice said was final. The third judge's case, the order is different from the usual order. I've changed the order into the Shamsher Singh being the first, literally. The next judgment comes out and says you have a collegium system. So expanded the Chief Justice in some fashion, and that distortion, I don't understand how it really can be justified. So you have a collegium system coming into being. So the Chief Justice now would be read to mean collegium, in whichever dictionary or lexis manner that you can deem fit. And therefore, you have the collegium deciding what is to be done as far as the executive is concerned. Once the collegium sends a finding, yes, it is open for the executive to reject it at the first instance or to send it back. But once the collegium resends it, well, then the executive has no further discussion process in this. In the backdrop of this, there's one feature. The second feature, you have 428 vacancies as on date. You have 3.15 crore arrears in courts. In Allahabad, for example, you have 160 seats for judges, and you have 76 judges working, and this goes across board in all states. You have more than 4,000 odd vacancies in the subordinate courts. You have, when you have this kind of system, you have vacancies. Second leg, you have arrears. On the third leg, you have people who are dissatisfied with the system of delivery of justice, and particularly, ladies and gentlemen, though you're youngsters, I might say this, it's very disheartening to say corruption, which has become the source of a big problem in this country. And if it starts striking at the root of the justice delivery system, it becomes really something which is undigestible and definitely not acceptable by any of us. So here it comes the 99th Constitutional Amendment, NJAC comes into being. It is made of a composition of a fairly senior level, you can't go more senior than that, to offset any question of only having political appointees, not only You have the Prime Minister, the Minister of Law and Justice, but you have two eminent persons. The idea is to offset, so you have a wider system of selection. In that selective process, you have 6 people who are there for the NJAC. The 99th constitutional amendment comes in. It is supported by everybody in this democratic setup. It is supported by the states. It is ratified. It is passed in Parliament. It comes into being. I am not saying that judicial review cannot be done. Of course, judicial review can and must be done. It came up for that consideration. But look at the grounds on which it was struck down. The grounds on which it is struck down is an extension of some sorts of Keshwanand Bharti, basic structure of the Constitution. It militates. Since when does basic structure decide the process of appointment? Basic structure of the Constitution only espouses justice delivery, independence of judiciary. You have an independent judiciary, whichever way you go. You have a fixed tenure. You can't even remove judges today excepting by way of impeachment, which has proved to be hopelessly unsuccessful. Justice Ramaswamy's impeachment motion failed drastically, and we've come to the conclusion, all of us universally, that there is no means of removing judges as it stands at present, unless again there is another constitutional amendment, which again would be subject to judicial review. So coming back to the proposition, what do you need for independence of judiciary? That judges can take action according to the law, according to the Constitution, according to the constitutional values, and that is the basis of which everybody must be accountable for. In this backdrop, you have the NJAC being struck down, on saying, well, you have, it is violative of the basic structure of the Constitution, which, as I just mentioned to you earlier, doesn't stand for any kind of finding on that score, because the process of law, the process of justice delivery is there, in essence, in every possible way. How you appoint the judges is a subject matter. Is it within the power of the Parliament? Is that within the power of the Parliament? If it is so, whether it is good or bad is not a ground to reject it. One of the principal arguments used against the NJAC was to say you have, it is possible to be misused. Every law is capable of being misutilized. Every law. I'm sorry to say this, but you're all either lawyers or potential lawyers. It can be misutilized. That is not the test. The test for any legislation is, ladies and gentlemen, to have, is it valid? Does the Parliament have the power? If so, it cannot be struck down excepting on grounds which are otherwise, let us say, basic structure of the Constitution, which is a anomalous situation. It cannot be so. Coming down to the other front of whether, in fact, you can have a system prevailing which is not delivering justice to the people. When we talk about the Constitution, that is ultimately between an academic discussion or between lawyers or between people who come within that category. But when you talk about people, I was just in several discussions with the people of this country, and the people of this country want a system which delivers justice, which we have a ratio of 14 judges to 10 lakh people. You look at America, it has 101. You look at UK, it has 50. Forget any other country. On the face of it, 14 judges to 10 lakh people is something which cannot deliver justice to the common man, least of all in any reasonable manner. You have vacancies, you can't deliver justice again, you have arrears. At the same time, you continue with that. If the system is not delivering, does it not require a complete overhaul? And that overhaul was by way of a constitutional amendment, so you had that come into being. And I think that is ultimately one of the justifications. Let us see Justice Kurian Joseph's comment. What does he say? He ultimately says, we all admit that the collegium system is having a problem. I don't think that's a legal argument. As I said, that's a second argument, which is outside the legal domain of constitutional validity. So you have people saying, we don't have trust in this system. We want the system to change. We want a fair system to deliver impartial justice to us. How can that be done? It is in that context, possibly, and the fact that the collegium has not been able to deliver. There have been aspersions cast. There have been names of corrupt judges who've been put forth. There have been challenges in the courts.
9 minutes.
There have been vacancies. So at the end of the day, if this is the backdrop of one of the judges of the NJAC judgment coming up with the issue, but then coming on to the second leg, which is a different chapter. Chapter 1, NJAC struck down. Chapter 2, collegium is bad, let's reconsider. Incidentally, I have been fully part and parcel of that process, and we had 11,000 pages of suggestions, 1,500 people coming from across the board in the country, including academicians, lawyers, scientists, doctors, criticizing the system, coming forth with suggestions. Those suggestions are the subject matter of the second part of this NJAC chapter, scrapping the collegium or improving it. Let us talk improving it. But effectively, if one system was struck down as being bad, if the NJAC was struck down as being bad, then why are we considering improving the collegium system? A direct admission that the collegium system is unacceptable in the way it is. Thank you very much.
Thank you, Dr. Anand. That was dot 10 minutes. And your concern of not having a chance to rebut, in the question answer round, the panelists make full use of rebutting the other. We had a very lively session between Dr. Swami and Mr. A. Jethmalani before you, so you will have that opportunity. Now I'd like to call upon Ira Regmi, who will be opposing the proposition.
Right. So let's begin with where ma'am ended, right? So we started off by saying that it's not enough to deem the NJAC unconstitutional, and therefore, like, this wasn't a valid ground, is where we ended, right? But what we need to look at is not just to say that it was deemed unconstitutional. We need to understand why was it deemed unconstitutional, right? Why is it that the Constitution has certain ideas that we believe that we should adhere to, right? What is this idea that once you say it is unconstitutional, you can't? What we're not saying that just because it's unconstitutional, you don't do something, right? We're saying you look at the logic behind it being unconstitutional, and that's exactly what we're going to tell you, right? Why it's enough to be unconstitutional. The idea is that the Constitution advocates for the separation of the executive and the judiciary, right? The separation of powers, and why that's important. I'm going to talk to you about that. I'm going to talk to you about the existing influence of the executive and how it's necessary to curb that. I'm going to talk to you about how the judiciary as a mechanism should be used to fix the flaws that democracy has. It's a popular form of governance, but it has flaws, and how we use the judiciary to fix it. We're going to talk about people, right? And that's what ma'am said. And we need to talk about what the people want, what the people feel, and how is it that we can ensure they have faith in the judiciary system, and that's what I'm going to talk to you about. Then I'm going to talk to you about the adequacy of the NJAC, right? I'm going to talk to you about why is it that it's not a fit model in this case, right? And then we're going to talk to you about remedies, where ma'am says that it's a principal admission, it's a concession when you say that, well, you know, the collegium does require amendments, right? But we're going to tell you, when ma'am says that if something that exists, if it's not working, it needs a complete overhaul, we're going to tell you why it does not need a complete overhaul, right? So let's begin, right? What is it? Why do we advocate for the separation of the judiciary and the executive, right? The idea is that there needs to be a proper check and balance between the two, right? These are very powerful entities, and especially the executive, right? And we need to make sure that there is a check and balance from the judiciary that comes into account, and that is the basic structure of the Constitution. When you're saying it's unconstitutional, you're saying that one segment has too much power, right? That one of the pillars of democracy always overrides the other, right? And that's what we don't want, right? We want, and what is it, right? Appointment of judges is it's one of the most basic things, right? Because if we're talking about the people who are going to deliver justice, and if you're telling us that there's going to be heavy political influence in appointing the people delivering the justice, right? We're telling you that that's a massive breakdown of the barrier between the judiciary and the executive, and we have a problem with that, right? Because we think that's a breach of the independence of the judicial system, and we believe that that's going to heavily politicize the judicial system, right? What am I talking about when I tell you that we need to fix the flaws in democracy, right? And one of the arguments that keeps coming up for the NJAC is that, you know, like, the court did something that was like completely declined the idea of majoritarianism, right? And that's what we're talking about, right? We're telling you that there needs to be a body that is non-majoritarian also, right? We need a body that also does not just cater to the majority and says, hey, you know what, like 2/3 of the people think this is fair, so it must be fair. No, it's not always fair, right? That's why we need to give a scope for the minority to also come and say something, right? And we believe, and that's the difference between the judiciary and the executive, right? That the executive tells you that a two-thirds is right? And the judiciary also looks at that possible scenario where perhaps the 2/3 is not right? And we dilute that entire essence when we tell you, when you come and tell us that, you know what, we are going to keep political members in, like, appointing the judicial judges as well, and we think that's a problem, right? Now let's talk about politicization of the judiciary in a sense, right? They might come and tell us that, you know what, like there's one leader of opposition and there's a prime minister and therefore it's all right, right? But we're not saying that one particular influence of one particular political idea is bad, right? We're telling you that an overall politicization of justice in itself is bad, right? We don't think everything needs to become a political matter that needs to be discussed by everybody. We think law is like, and as you said, you're all law students, right? Is very objective. It has its own certain standards that it does adhere to, right? And we believe that those should be left on to the judges, right? And therefore, we don't want everything to get politicized. Why else do we not want it to be politicized? And that's where the people come into concern, right? And that's where we talk about the people. Let's talk about the mindset of the Indian people, right? What is it like? Is it like, oh, like we're not Canada where we're like, oh, you know, like our politicians are great, we love them, and we love it when everything is politicized, right? We don't like it, right? Because India is not a country where people have always been very happy. They've always been very apprehensive about politicians, and well, like I'm sorry to say, but our politicians have given us enough reason to bear that apprehension, right? And we believe that therefore it's very essential for us to not politicize so that people have faith in the justice system, right? If justice is being delivered to like victims or whatever, to like all kinds of people, I need to be assured that the person who's giving me justice, I trust that person, right? But if I see this dilution of politicians that I hate anyway, right, I'm not going to be very acceptive of that judiciary. And that's why I believe like justice becomes very diluted, right? Unless people have faith in it, unless people believe that the justice that's being given is actually just, it's not justice, right? Because the people need to believe that there is justice that's being delivered. And that's why we tell you that the faith of the public in the judiciary is very, very important. And I'm sorry to say that with the Indian public sentiment, that's not going to be the case with political intervention, right? Now let's talk about the NJAC in itself, right? So like the other idea, why is the collegium better, right? And the basic idea is that these are lawyers who are going to hire lawyers, right? And we believe like a simple like matter of metric, it's better because they know what is required, right? They know what to look for. They know what the metrics are. They know exactly what to do, right? You involve people who have been partially involved in law, have seen things, but aren't directly involved in it. They're not going to have a proper idea, right? Now let's look at this, right? What is it? Laws need to be aspirational. They need to look at the future, right? So today, if we're saying that let's allow for this part, what are we saying? We're allowing for the executive to meddle with the judiciary at a certain level, right? But where do we stop? When do we say that this is enough, right? For us to be able to say this is where we stop, you need to first not allow there for a leeway for people to say, hey, you know what, this happened, this is the precedent, so maybe this can also be done. Maybe, you know what, maybe like directly some people should be allowed to hear, maybe the judge should directly be appointed by only the leader of opposition or only the prime minister, right? So we allow for these kind of scope, this leeway for there to exist once we say that a little bit of intervention is perhaps all right? No, it isn't, because later it's going to allow for more intervention, because that is the beginning of intervention, right? And that we believe is the aim of the political propaganda, so that they can make judiciary the mouthpiece of their propaganda in the future, right? And we believe that's very, very dangerous, right? And another thing, right? We're talking about like two political parties being involved. Let's look at the case right now in itself, right? We don't have a clear opposition, right? And in a case where there is no clear opposition, who is it that's going to be the leader of opposition there, right? And let's not even talk about a scenario, right? And let's talk about how this is very dangerous, right? Because if you're going to talk about the future, you're talking about two entities, a government and an opposition, where there is no fixed metric as to who they're going to be, what their ideas are going to be, what their dynamics are going to be.
Like 9 minutes.
Sure, thank you. What their dynamics is going to be like 15, 20 years down the line, where you say there's going to be a leader of opposition and a government, right? We don't know if they think alike. We don't know if they're like the leader of opposition is so tiny that it doesn't make a difference. We don't know that maybe 15 years down the line, this is going to allow for all judges to just be like replicas of what the Prime Minister believes, right? And we think that's a very, very dangerous scope that we're allowing for here, right? And now let's talk about what ma'am was talking about in like when she said that it was limited to consultation in the Constitution. Never did it say that like, you know, like the collegium, the president needs to abide and it's a binding thing, right? But let's look at what the implication of this is, right? Who then takes the call? Right? If you're saying that it's just a recommendation, who takes the call then? If this is just a recommendation, does the president or who takes the call? And that's where we tell you that that is what the debate is about. And we tell you that the collegium should take the call. If remedies are required, we're open for that. Thank you.
Could I please call upon Mr. KTS Tulsi, who will be speaking in support of the proposition.
Learned members of the House, my worthy opponents, and my co-speakers. I hope you know that there is no country in the world where judges appoint judges. No country. Countries far more prosperous than us, countries far more successful democracies, countries which are not only affluent but actually have very, very powerful, strong judiciaries. Judges don't appoint judges. What happens in the United States? In the United States, it's the US Attorney General who moots the name for the appointment of a federal judge. And that is sent to the president. The president sends it to the American Bar Association. The American Bar Association holds a nationwide ballot. So it's not hush-hush. The ballot is held. And after that, if the Bar Association endorses, it is sent to the Judicial Committee of the Senate. And the Judicial Committee of the Senate holds public meetings. In those meetings, a notice is given to the objectors, and the notice is given to the nominees. The objectors bring their evidence, witnesses, documents, why they are objecting to somebody being made a judge. And after that, the nominee cross-examines them. Then the nominee brings his evidence, witnesses, documents, and the objectors cross-examine them, public hearings. They are all reported in the newspapers or the televisions. And after that, if the US Senate Committee, Judicial Committee of the US Senate approves, it goes to the President. And they are appointed. What happens in India? Over a phone call, the collegium is called. 5 people will decide whom they are going to appoint. The bar doesn't come to know. The minister has no say in the matter. The Prime Minister's office has been made into a post office. What did the Constitution of India say? The Constitution of India says that a judge of the Supreme Court or the judge of the High Court will be appointed by the President. Will be appointed by the President in consultation with the Chief Justice. Now, what happens? In the first case that Ms. Pinky Anand referred to, the Supreme Court said consultation means concurrence. Can the court alter the words in the Constitution? Did the Supreme Court not know that this matter was extensively debated in the Constituent Assembly? And the Constituent Assembly expressly dealt with the question as to whether the power should vest with the President of India or with the Chief Justice of India. And Dr. Ambedkar is recorded to have said that we will not leave the power to the Chief Justice. This power must belong to the head of the country, head of the Republic. And still, somebody can distort the Constitution? Can anybody still alter the words in the Constitution? And here, what's the problem? NJAC, National Judicial Appointment Commission, only says that there will be law minister also who will be a member. But the Supreme Court has too much of a trouble with that. Law minister? Why law minister? We don't trust the law minister. We are far above the law minister. The real question then, which irks me, is that they said, who are these two jurists? What do you mean by eminent jurist? Is it that they think that no one can be more eminent than them? Can this country not believe that there are other eminent people apart from judges? And they say there is no criteria. I would like to narrate to you an incident that happened. Earlier this year, I was attending a Commonwealth Law Conference. And there was a session named Judicial Appointment Commission. Various countries have Judicial Appointments Commissions. The Chief Justice of Scotland was presiding over the session. There was a judge of the Supreme Court of Canada who was a member of the panel. And there was also a lady judge from Sri Lanka who was also a member of the panel. The Chief Justice of Scotland said, we have a Judicial Appointment Commission, 24-member Judicial Appointment Commission. And all of them are laymen. A proposition was mooted in the elections that let there be at least 2 judges and 2 lawyers. It was turned down. They said, no, we are the consumers of justice. We will decide who should be the judge. In this country, the judges think that they alone will decide who will be the judge. And the law minister also cannot sit in the collegium or in the commission. The Prime Minister will have no say. The constitutional system of parliamentary democracy is that the President is a titular head and he is advised by the Council of Ministers. Council of Ministers will advise them about everything, but not on the matter of who should be the judges. This is judicial tyranny. And I strongly oppose this. I believe Supreme Court of India has prescribed transparency as the panacea to all ills in the executive. Why do they not apply it to themselves? When it comes to themselves, they say that no, we will do this in a hush-hush manner. We can't tell the bar that so-and-so, what do you think about him? Because the bar is irresponsible. It's the same argument as the Churchill when India became free, that you can't leave this country to these scoundrels. He called us scoundrels. The same argument, judiciary is too elitist according to me. They think that no one else has the welfare of the nation in heart. That's not fair. There are such eminent parliamentarians who are equally concerned. Why could they not be considered to be eminent jurists? There are such outstanding professors. When I was a student, I heard the speech
9 minutes.
of Mr. Upinder Bakshi. What a giant! And can he not be considered to be an eminent jurist? Does the judiciary or the Supreme Court feel that there is nobody else? And why can't we have a in a democracy? Ultimately, the power vests with the people, and people must have a say in the matter. I would therefore also like to mention need to believe. ERA says there is need to believe that there is justice. Yes? What justice? Do you get justice in India? If you do, after how many years? On the average 10 years. 3 crore 20 lakh cases pending, and we still believe that we are getting justice.
10 minutes.
We definitely need better system. We need improvement. Thank you very much.
May I now call upon Akash Patnaik, who will speak in opposition to the proposition.
At the outset of this debate, this motion felt a lot more intimidating being a non-law student, but hearing what side proposition has to say has made things a lot easier, right? So let's look at what they've had to say today and break this down. The first thing they talk about is things like corruption and delays, and then Mr. Tulsi comes up and talks about how countries across the world don't have the collegium system, to which we ask them, do they have the NJAC, which is not the case either, right? But let's move on further. What's the difference between a United States of America not having the collegium system versus us? Firstly, they don't have the NJAC to replace it, and at the second level, they don't have a constituent assembly and a parliament like ours where we find our leaders napping and watching pornography, right? We don't have that kind of faith in our government like they do. But let's move on a little further. Corruption or transparency. We ask them right now, how does 6 people versus 4 people increase the amount of transparency that exists? All that happens in what side proposition is suggesting is that instead of being 4 people on the conference call, there will be 6 people in the conference call, which will be equally hush-hush, right? Where are the people getting to see some debate or discussion happening between these members of the NJAC? Is there any qualitative or quantitative metric that is revealed to the people from the decisions that ensue from the NJAC? No, right? Do we have any idea of how that decision of these 2 eminent persons also takes place? It's a decision between the leader of opposition, the Prime Minister, and the Chief Justice, right? Now understand this. Who are these 2 eminent persons, right? How are they accountable at any level? Who are they accountable to? We don't know which profession they're going to be from. We don't know how they're going to be accountable to the people at any level. So what form of democracy is this, that we have 2 people that is elected by an opposition and the ruling government and the Chief Justice? What metric is this, right? We don't see any clarity as to how this is democratic in any way, right? But coming to delays, right? Their solution is, in this debate, to compensate the collegium system has led to all the problems that exist in terms of like appointments, in terms of delays. How does the NJAC solve this is the question we ask them at the first level, right? An NJAC, in our opinion, can lead to further delays, right? We think that 2 members can hold this session to veto, right? So even though a Chief Justice and 2 judges might think that, you know what, there's something that needs to be done, these 2 eminent person who we don't know who they are and can simply hold this like session to ransom and take any decision that they might want. But let's come and understand where they've completely abdicated from the Indian reality, right? And this is what Ira spoke to you about in her first speech. We live in a country that has insane amounts of corruption, has immense diversity, and has multiple minority groups as well. The idea is this. The basic structure suggests independence to the judiciary. Their response to this is, this hasn't been compromised upon. Now answer this to me. Those who will keep a check on the government will be appointed by the government. We don't think that's a really independent system to begin with, right? The response to which will be, no, but you have those 3 other people. But I don't think a 2-member veto can really solve that. Also, will these 2 eminent people be independent? Let's understand this. We think that any kind of appointment or any kind of functioning in any kind of setup, whether it's corporate or government, works on the system of reciprocity. You were put there by these people. You were put there to push a certain agenda. How can we be certain that these people will not go ahead and engage in this kind of reciprocity, right? They're in this position because of the idea of the NJC. So we think that reciprocity now comes in at 2 levels. Firstly, in terms of these 2 eminent persons who are put in there, the law minister who is obviously going to push the agenda of the government, and the judges now appointed will be far more different than those appointed in status quo who would have perhaps taken different decisions. So we think that reciprocity is coming in at multiple levels. What is the check and balance to that? We don't know. Are these sessions going to be held in like public? No, they're still going to be held in back alleys, in like closed rooms where people are going to discuss things based on whatever subjective criteria of justice that they want. The only difference will be now there'll be 2 other people who will have a vested interest. So let's do a comparative, because that's something that hasn't happened in this debate so far, right? We think that they've completely talked about how the collegium system is problematic, but never really compared it to the NJC. What's the comparative here? I don't think either side can come up and say that in both scenarios they're going to be completely fair. Yes, of course, there'll be some kind of partiality, some kind of favorability in terms of who you suggest. There's nepotism here, there's nepotism there. The only problem is that in the NJAC, along with that nepotism, you also have a vested interest that comes in from a political level, and we think this political level vested interest is extremely problematic, right? And now let's understand this. I'm not going to go all out against one political party. I'll point out to you how the 2 major political parties aren't really people who you can trust with any kind of like judicial decision in this country, right? Let's understand the 2 biggest issues in this country right now. Corruption and intolerance, right? Corruption is a system where you need the judicial system to go ahead and be the last bastion and go ahead and stop any kind of corruption that the government might do. What is the case of corruption? It is against the government, right? You're going to be filing a case against the government. In that scenario, if you have a judge who is slightly favorable to the government in power, it's highly problematic because that individual or that community that has been affected by that corruption has no real say, right? You don't really have someone standing up for that. We don't think that they have a system to correct for that. But in terms of intolerance, right, specifically in the kind of scenario that we live in right now with the Modi government and the BJP, right, where you're necessarily going ahead and subverting any kind of systems of justice, they're going ahead and sidelining all kinds of procedure. Do you really want the justice system to be in the hands of someone who is not even being tried, right? We think that that's a huge problem, right? We don't think we can let something like a government really determine those actions. The independence of judiciary. We don't think faith is something as simple that can be sidelined, right? We don't think what Ms. Pinky Anand came up and said in terms of, it's just the basic structure, right? We think that independence of the judiciary is one of the most essential things in a country specifically like India. What is this opinion going to be? And their argument is democracy, right? And this is precisely what we're going to talk about. A democracy doesn't mean that only the majority gets a say in ideas that need to be propagated in the country, right? We think that the point of the justice system is to specifically be there for that minority. And in a scenario where you have an executive which is going ahead and like bulldozing minorities left, right, and center, where you have like riots and issues happening every day, where people are being lynched for eating beef and being attacked, when you're going to also have a judicial system that is influenced by that very entity, we don't think it really solves problems for those people eating beef, right? Or actually not even eating beef in the first place. What the issue comes in at that level is understanding that you cannot allow this influence. In terms of the Congress, the same thing comes in, but not in terms of intolerance, but in terms of corruption, how they have multiple cases. They want to compare to a country like the United States of America and say that they have this kind of system, but that's a really false aspirational value for a country that has scams that aren't like lakhs, but lakh crores, and they happen every single week. Who is going to have the ability to stand up against these people if you don't even have faith in the justice system? Their response is, faith in the justice system isn't lost. Understand this, and I'm going to be as crass about it as I possibly can. If I'm a Muslim person living in India, I don't really have faith in my executive right now because it's someone who has possibly committed riots at one point of time and is followed by RSS, who's consistently clamping on my rights. The only person I trust is the judiciary. If that judiciary is further compromised and is further attacked or controlled by this political system, which is what they're trying to evade, right? They're trying to say, no, but there'll be these 2 eminent persons who are going to be these really, really nice people who really want nice things for the country. How can you ensure this? These two people are being appointed by political parties. They're going to be having the law minister on board who is also going to have a political interest. 3 people out of a 6-people committee are going to have a vested interest, out of which 2 of them can also pull a veto. These people are going to be powerful and they can exert influence on this system. So we essentially need an independent judiciary. So if a Muslim man wants to go ahead and fight a case, he's going to think 10 times, because not only does he have an executive who's going to put him down and quash his rights, the only entity that can uphold his rights, uphold this individual's fundamental rights, is also compromised, right? And this is where you come to the idea of rights, right? And this is essentially important. The only entity in this country that has consistently upheld fundamental rights of people, it's the judiciary, right? And that's the only entity people trust to uphold those fundamental rights. If those fundamental rights are now not upheld to the same standard, minorities and people who are anti-state or going against the state have far less bargaining power in a system that is already run by a majoritarian setup because of the idea of democracy, right? Now coming to the idea of corruption. If I'm someone who's, for example, filing a PIL or filing a case against the government, I'm far more apprehensive now because of the idea that this issue has been tampered with, right?
9 minutes.
Yeah. So let's finally come down to the comparatives in this debate. The idea of delays. They're talking about delays when they're talking about a political system. Do you really think that the leader of opposition and the prime minister are ever going to come on agreement on anything? We think there's the individuals, the idea that 2 people can hold a veto. You have 2 conflicting interests in this NJAC, right? You have the judges, and then you have these 2 eminent persons and the law minister. They're constantly going to be these deadlocks and further delays, right? So tell us how those delays are dealt with in the first place when 2 people can just veto and hold you to ransom and not get things done. At the second level, you have nepotism along with the clear vested interest of a political system. At the third level, they haven't really address the Indian demographic or the Indian society that we live in that is plagued with corruption, that's plagued with diversity and plagued with the idea of multiple minority groups and fringe groups being attacked consistently by the government. Let's not stand here and pretend that we live in a country where there isn't this intolerance. Let's not pretend that we're living in a country that doesn't have a prime minister who's been accused of riots. Let's not pretend we've had a previous government that was held in multiple corruption cases.
10 minutes.
We're very, very proud to propose.
The last speaker speaking for the proposition, Isha Jain.
Ladies and gentlemen, over the course of my speech, I'm going to engage with the criticisms of the NJAC that's been brought forward by side opposition and tell you why, at the end of the day, this commission still is a better method for appointing judges to our higher judiciary than the collegium system as it stands. Now, the collegium system involves the Chief Justice of India, along with the 2 or 4 senior-most judges of the Supreme Court, having both the recommending power as well as the final say in appointments to the higher judiciary. However, the system has received substantial criticism for being non-transparent and for overly insulating the judiciary from any sort of outside criticism into the people who then go on to occupy these posts. In the absence of guidelines circumscribing the discretion of judges or the collegium in the appointments process, and in the absence of transparency in the deliberations that precede this appointment, it has been very easy for the public to attribute perceived non-suitability of judges and failings of the justice system to these failings of the collegium system. We think allegations of nepotism and favoritism in the selection process are not at all uncommon, and that isn't completely unjustified. We think irrespective of the factual honesty or integrity of the judges in the collegium, it's important that justice not only be done, but also be seen to be done. And for that, a manifestly non-arbitrary process of selection of judges is a constitutional necessity. We've heard from side opposition that the NJAC undermines the independence of the judiciary by passing the primacy of the judiciary to the executive in this matter of appointments. However, if you actually look at the scheme laid down in the constitutional amendment as well as the act, the primacy of the judiciary still vests in the judiciary itself in the appointments process, even though it might not be as absolute as a form as it exists under the collegium process. We think since the judiciary occupies 3 out of the 6 positions on the commission, it gives the judiciary the most powerful voice in any deliberation on that commission. We think furthermore, the Chief Justice of India does have a vote in the appointment of those 2 eminent persons. And finally, and most importantly, the provisions of the NJAC Act ensure that the members of the judiciary have the power to veto the appointment of any person they see unfit to stand for that appointment. And so effectively no person can be made a judge without the concurrence of the judiciary, even under the NJAC Act. So we tell you that judicial primacy cannot be equated with the final and absolute power of the Chief Justice of India to decide on all appointments. We tell you this would be irreconcilable with a plain reading of the constitutional scheme that was laid down by the drafters of our constitution. As Dr. Anand already told you, it envisages the executive in the first place, the president appointing judges only on the consultation of the members of the judiciary. We tell you a more reasonable understanding is that a limited judicial primacy and consequently the independence of the judiciary is protected under the NJAC by ensuring greater numerical representation of the judiciary and consequently greater voting power to them, in what is essentially a consultative process between the judiciary, the executive, and members of civil society. But a more serious criticism of the NJAC is that it allows for an impermissible degree of executive interference, and thus that there's a threat of the politicization of the judiciary. Now, admittedly, the dangers of a politicized judiciary cannot be exaggerated, considering that the government itself is the largest litigator before the courts of law, considering that the judiciary is the most powerful protector of civil liberties of the individuals against excesses of the governmental institutions. And we tell you for this reason, it's important to note that there is only one member out of 6 on the National Judicial Appointments Commission who is a member of the political executive. That one member is not enough to push through a candidate objected to by all others. That one member is not even enough to veto a candidate who is supported by all other members of the commission. And we think thus there's no real threat of this one member being able to push through candidates on the sole basis of their fidelity to the government of the day. They tell you there's also a threat of politicization of the judiciary through the Prime Minister and the leader of the opposition having a say in who these eminent persons on the commission are. However, we think it's absurd to suggest that the leader of the opposition would have an interest in appointing persons that would be favorable to the government of the day who he is in opposition to. We think for that reason, the fact that there's a Prime Minister or leader of the opposition as well as the Chief Justice of India offers significant diversity in the selection panel of these eminent persons and ensures that there are enough conflicting viewpoints that not only one political ideology is backed by these eminent persons who are selected. But the requirement of 2 eminent persons on the commission has also come under attack for failing to lay down specific qualifications of such eminent persons. And it's also interesting to note that a similar vagueness of terminology is used in Article 124(3) of the Constitution, which states that the President's opinion that a person is a distinguished jurist is sufficient qualification for them to be appointed as a judge of the Supreme Court of India. And we tell you, similar to the provision governing the NJAC, this lack of explicit definition is offset by the fact that such appointment is being carried out by such high constitutional functionaries. We tell you, if the Prime Minister and the leader of the opposition and the Chief Justice of India himself can together not be trusted to appoint eminent persons from the legal field who truly are of ability and integrity, then nobody else can. And then there is never the possibility of an argument that anyone outside of the judiciary may have any say in the appointment of judges. We tell you, in any case, it is always open for the court to demarcate broad guidelines as to how this term eminent should be understood and thus save it from the vice of unconstitutionality. But finally, how does the NJAC solve these problems of the collegium system? We think essentially it institutionalizes a much needed system of checks. We think through its carefully balanced membership, it ensures that neither the judiciary nor the executive has an absolute or final say in the appointment of judges. And we think thus it strikes a balance between the position in India before 1993 and after 1993, where the primacy of the executive got a lot of criticism because of the threat of politicization of the judiciary, where the primacy of the judiciary got a lot of criticism for the possibility of nepotism and favoritism in the appointment of judges. And thus we think also because it importantly introduces this independent component of eminent persons into the appointment process, it deserves to be lauded. The absence of political affiliations or any manifest vested interests of such private citizens appointed to this commission will lend a great degree of transparency to this process and go a long way in securing the faith of the people in the judicial process. We think the NJSC also makes the appointments process more transparent by specifically taking upon itself the duty of ensuring that appointed persons are of ability and integrity. So it's wrong for them from side opposition to say that no criteria or no suitability metrics are laid down in the Act, because these two words are specifically stipulated. This is in stark contrast to the collegium system, where no criteria or no metric has ever been employed by the collegium, and they have never been answerable as to what metric they have followed in the appointment of judges. But we think a point that has been missed out by side opposition so far is the fact that the NJSC creates a much more broad-based system of appointments. Because while the present collegium system may be constituted of the senior most, the most eminent judicial officers of our country, it is essentially parochial in nature. It is worth considering whether there truly is diversity in the social, economic, and political backgrounds of the judges in the higher judiciary of India today. And worth considering whether this may be implicitly affecting the appointments process, or even more perniciously, the dispensation of justice to persons who do not come from that same background. We think, therefore, the requirement in the NJSC Act that it should contain one eminent person who is either a woman or from one of the backward communities should not be dismissed as merely a populist political move. We think, as they have already pointed out to you from side opposition, the judiciary is meant to be the protector of those who may get overlooked by or trampled upon by the majority and excesses of a democratic parliament. And for that reason, it's necessary for them to be able to effectively carry out this role of a protector that they empathize with and take into the accounts of views of persons who otherwise don't have sufficient political power. We tell you that these are persons and people from these backgrounds would ordinarily never have a say in the collegium system because they are so underrepresented in the higher judiciary today. So in conclusion, we tell you that the NJSC should not be seen as a reversal of the balance of power which shifts the primacy from the judiciary to the executive in the appointment of judges. We tell you it should be seen as an attempt to institutionalize the consultative and broad-based process of appointment that the drafters of our Constitution saw fit to institute in the first place. We admit that the amendment and the Act do have their shortcomings, but these shortcomings can and should be overcome in order to strike the delicate balance between protecting judicial independence and preventing judicial insulation. Thank you.
Can I please call upon Mr. Bishwajit Bhattacharya to speak, opposing the proposition?
Mr. Chairman, sir, distinguished ladies and gentlemen on and off the dais. The Constitution of India is supreme in the country. What does the Constitution say? You read Article 124, 127, 128, 217, 222, not a single judge in the country, in the High Court or Supreme Court, I repeat, not a single judge in the country, in the High Court or the Supreme Court, can either be appointed or be transferred from one High Court to another after consultation. The word is after and not in consultation, as my learned distinguished friend Mr. K.T.S. Tulsi stated. So when you, after consultation of the Chief Justice of India, who appoints? President of India. And President of India is not bound by the Council of Ministers' advice. In three matters: appointment of the Prime Minister, dismissal of the Prime Minister, and appointment of judges. So therefore, who signs the warrant? Rashtrapati ji. The Chief Justice of India does not sign. So to say that in India, judges have been appointing judges is an absolute disinformation campaign which has been going on by parliamentarians.
700 odd parliamentarians and the state legislatures have formed a Mahagathbandhan. This is the biggest ever Mahagathbandhan in the country. You can see the Congress MP and the BJP spokesperson on one side. Not only that, the Prime Minister, the leader of opposition, all political parties have joined hands. Why? To take over the appointment of the judiciary. Why? Because the judiciary has been the most inconvenient institution in the country which is purging on political corruption. May I just say that these 5 articles are basic immutable structures of the Constitution. We need not go to United States and Scotland and Sri Lanka. We have to look at Indian Constitution. And in Indian Constitution, it is the President of India who appoints judges. Government can always stall appointments. Gopal Subramaniam, recent instance. After consultation with Chief Justice of India, his name was appointed. It was stalled by the government. So I am unable to accept the argument that the interpretation which Supreme Court gave in the 1993 and the 1998 judgment, that in consultation, after consultation of the Chief Justice of India, means yes, in the normal circumstances, it is binding. But the government can't ferret out any abnormal circumstances. And what does the NJAC say? This pristine position of Chief Justice of India, if you go through the Constitutional Amendment Act, the name of Chief Justice of India has been knocked out from Article 124, 127, 128, 217 and 222. Can you believe that? The institution of Chief Justice of India's name has been deleted and substituted by what? Substituted by National Judicial Appointments Commission, where he is 1 in 6. And what is his additional power? Only to fix the date of the meeting and the time of the meeting, to be convened by Secretary Justice Department of the Union Law Ministry. So that is the mockery of constitutional defacement and defilement which took place by this constitutional amendment. And just because all the parliament members and state legislatures have united, suppose tomorrow all the parliament members unite and say that if police arrests a person on reasonable suspicion for any activity which in their opinion is prejudicial to public interest, no court shall give him bail for 1 year. Whom do you go to? Do you go to Parliament? Do you go to Home Ministry? Do you go to the Police Commissioner? You come to the judiciary. So it is the judiciary, it is basically protecting the fundamental rights. And this composition of NJAC, Law Minister represents the biggest litigant in the country. 60 to 70% cases in the higher judiciary, the Law Minister is heading the central agency. So a litigant sitting in the court, sitting with in the appointment process of selecting a judge. Can there be any more perversity than this? So therefore, I submit respectfully the strong statements like judicial tyranny, sovereignty of the parliament are totally misconceived. They do not reflect the wordings of the Constitution, and there is no sovereignty of either parliament or executive or judiciary. Sovereignty is only of the people of India, reflected through the Constitution. We, the people of India, has given this Constitution to us. And if that Constitution is attacked by entire legislatures, then Supreme Court will smash it. It has done, and it will continue to do so. That is how the democracy in India thrives. We have to think of a situation. Well, none of us will be in this world. What kind of India shall we live? Leave for the next generation. Do you want an executive tyranny? Do you want the executive and the legislature will join hands to trample upon fundamental rights and to perpetuate corruption? I acknowledge the fact that everything is not well with collegium. Collegium needs improvement. But can the remedy be worse than the disease afflicting the system? And what is collegium? What is the meaning of collegium? That is also another disinformation campaign going on. The Constitution says Chief Justice of India. After consultation, all that collegium means, this consultation process, Chief Justice of India, in turn, will have to consult with 2 or 4 of his colleagues. That is the meaning of collegium. The pristine position of the Chief Justice of India has been knocked out. So today, by this NJAC, it is neither consultation, it is neither concurrence. Chief Justice of India has been made a persona non grata. He will sit as a member on 1 in 6. It is 3 versus 3. Bargaining will go on. And all the 3, 1, 2, 3 in the Supreme Court are very dangerously close to retirement.
9 minutes.
Thank you. Legislatures will frame laws and say, you retire, we will make you this chairman, that chairman. Where are we going? You all know what is happening. So, ladies and gentlemen, this is a grave situation for the country. Supreme Court has risen to the occasion, and as very, very brilliantly stated by some of the speakers here, the faith of the common man in that institution, in that highest dome, is most important than anything else. If that faith goes, the democracy in India collapses. Thank you very much.
We'll take some questions now.
The first question, could I just request a question only if it's for those in favor of the proposition? It's in favor of the proposition? Yeah.
I understand that the majority of a country's entire legal jurisprudence and the system depends on its receptiveness to its changes. But I have a fundamental problem. The entire issue revolves around what all maladies face the judicial system, where we say there is a lot of pendency, we say there is a lot of corruption. These are the 2 key points which have been brought before this House. And I will be allowed to say that these 2 are more prevalent at the lower judiciary rather than the higher judiciary. And statistics clearly support it. And to sharp contrast this fact, the entire process of appointment of lower judiciary is more organized, more institutionalized, and more objectively satisfactory as compared to all the debate that's going on about higher judiciary. So if the idea is to bring in a system of checks and balances, clearly NJAC, its constitution, and the process that has to be followed for appointment of judiciary does not address a system of checks and balances. So the debate is essentially whether you are ensuring a system of checks and balances, which you are not. So if the collegium system has flaws, there can be an alternative without replacing the collegium system and bringing in more meat to it where you redress what is lacking there, not scrap it from its entirety. Can you please answer this?
Yeah, ma'am, you can take that question, and also if you have any rebuttal, you can also add that on.
I find the question a little head-on. You say there's frailties in one system, therefore it's not a ground to change it, improve it. There's frailties in the other system too. I don't think we are taking the situation as it should. The logical one is the answer of what the public aspire. I'll come to that a little later also. But the real question is, what can be done? What is the constitutional method? And what has happened, is it correct or not? I'll just answer that in a little more detail to say this. Does the Parliament have the right to put up a system of appointment of judges? Have the earlier judgments which have put the collegium system into place, which you today say is sacrosanct, and therefore don't change it, improve it, is that valid or not? That is a consideration which is undergoing here. To say that there are frailties in one system, improve it, don't bring the other system because there are frailties, I think we're becoming too judgmental. So let us go back to the basic framework to say who has a right to do so, are they doing it, is it outside their power? And that really is the only question that needs to be addressed. We don't have to decide whether a particular judge will appoint a gay person as a judge or not. That is not the criteria. What they will do is a subsequent issue. The question is appoint them there in the process that is meant for appointment and the process which the Parliament is competent to do. If it is so, then let us not look around for any other questions or answers. I had one rebuttal
Sure, please go
on
ahead.
Ira and Akash. Very briefly,
Sure.
As I said, it's always more fun to be there in a debate. Ira essentially said, in fact, both of them talked about the same thing, politicalization. The whole argument, at least of Ira and Akash, was that NJAC is politicalization. Akash further went on to say minorities had no faith in Modi government because Modi government did this and therefore there is a backing of etc. Therefore, no faith in Modi. Therefore, politicalization. Therefore, bad. How does this translate? I am not understanding. I've got my answer. The only other part I want to say, ladies and gentlemen, on rebuttal is this. There is a problem, but what we need to ensure is, and what we must do and what we have done in the past, is let us keep our institutions intact. We as India have survived because we have nurtured our institutions. We have kept them within a certain framework. The NJAC, I am not saying is the best thing that happened to humanity. But if it has happened in pursuance of the Constitution, how it will perform, how the eminent persons will be again selected, that is laid down, what process they will follow. Yes, it should be transparent, as some of them said. So let us leave that framework later on. But let us keep the faith in institution alive, otherwise we will be left with very little to leave for the next generation.
Thank you, Dr. Anand. We have a question for the other side now.
My name is Gauri. I actually have a question for Mr. Bhattacharya. More than a question, it's a bit of an observation. What I observed was the entire argument that you made was not based on why the NJAC would be unconstitutional. Like you didn't go into the constitutional validity of it. Rather, you spoke with regard to, I felt the ego of the Chief Justice of India being part of a committee and not given the stature of a single body, or you went into the corruption of the Parliament rather than actually going into the constitutional validity. So my question is, if you can't trust the Parliament, which runs the entire country, if you can't trust them to form even 50% of a committee, and the only argument that you made to declare the NJAC unconstitutional was corruption, can we just declare the entire Parliament unconstitutional because it's corrupt?
Let me just clarify. It is not a question of trust. It is a question of pure constitution. And Chief Justice of India is the grand norm of India's constitution. So when Chief Justice of India occupies the pristine position in the appointment process of Article 124, 127, 128, and 217 of the Constitution, to knock him out and to replace and relegate him to 1 in 6 and bring in the executive and political influence, that is destructive not only of the grand norm of India's constitution, but it is also destructive of independence of the judiciary, because appointment process of a judge is the most important facet of independence of the judiciary. As far as corruption is concerned, corruption judges, in order to, one point I'm just telling you, adding, which is beyond this debate. If parliamentarians, they are more interested in taking over the appointment, but they are not interested in punishing the errant judges. They should bring out a law where errant judges can be punished. But have you ever seen any parliamentarian, any legislature bringing out a law to punish an errant or divine judge? They are not interested. They are only interested in capturing power so that Courts can be packed with political appointees with a particular sort of ideology. That's all they want.
Thank
So
you,
it
sir.
is independence of the judiciary and the basic structure of the constitution, they are inextricably linked. And as Justice Krishna here has very categorically stated in Indira Nehru Gandhi versus Raj Narayan, you read paragraph 343, AIR 1975 Supreme Court page 2299 at page 2385. Basic structure is not a twinkling star up above the sky. It is a terrestrial concept having its habitat within the four corners of Indian constitution and not the constitution of the United States, America, Russia, Germany. We need not quote other constitutions. What is being violated is the basic structure of India's constitution.
Thank you. We have a question from Mr. Tulsi.
Hello, sir. So my question is that the proposition postulated that on the arguments on the basis of eminent person, that who can be the eminent person and so on. Sir, what I believe that the question in the fourth judge case was not that who can be the eminent person and who cannot be the eminent person, or whether judges believe that they are more eminent than some other person or political figure or something like this. I believe, because I was attending the courtroom number 4, item number 401, and when Mr. Arvind Datar was presenting this particular argument, and the argument was why the concept eminent person is vague. The reason was not that who can be the eminent person. The reason was that out of 70 statute, what he researched, and since I also assisted Mr. Datar in this, why out of 70 statute, 67 statute in India provides or define who are the eminent person in that particular statute itself. And why, and the remaining rest of the 3 institutes which did not define who are the eminent person and who can be the eminent person was some state act, some bar council act, or some sugarcane act in UP or Rajasthan and MP. And out of 70 institutes, 67 institute which was passed by parliament defined who are the eminent person. So what was the reason then in this act, God knows deliberately or non-deliberately, why parliament did not define who are the eminent person in this paramount constitutional amendment? Thank you.
See, if my memory serves me right, I was not a lawyer in that case. But the ground on which, one of the grounds on which it is struck down is that there is no criteria for determining who is eminent and who is not. And I very respectfully want to say to the Supreme Court, according to me, every Indian is eminent. According to me, NJAC was a very small step forward. I wish a day comes in this country when judges are elected and people have a real say in the appointment of judges. Then only the judiciary will become truly accountable. And ultimately, to say that let's not suspect the competence of the Indian people. The greatest achievement of India after attaining independence is that we have a vibrant democracy. We have regular elections. There may be that so many undesirable persons get in, but the achievement of the parliament in being able to uphold the constitution and to mold it to the changing times is phenomenal. In South Asia, India is the shining example of democracy, and we need to be proud of it. The judiciary, we are very proud of the caliber of our judges. But the problem is the delay. Inordinate delay dilutes justice and denies justice.
Thank you, Mr. Tulsi. We have a question for the opposition.
Good evening, everybody. I'm Nishtha Agarwal, and my question is to the opposition. Anybody of you could answer. I have 3 questions, particularly even after the whole debate, which remains unanswered to me.
She has one.
Okay, I have one. My question is that in light of the judgment that I have read and that I've understood, we say that the judges said that it is unconstitutional, taking away the independence of the judiciary, that is unconstitutional. But my other question is that
primacy and the supremacy of just giving primacy and supremacy to just one institution, just one pillar of the democracy, that is the judiciary, and holding the other two pillars totally unworthy of anything, any welfare that that we can rely on them, that they would have a heart for welfare of the society. And please answer it in the light of what came yesterday, the statement of Chief Justice of India when a charge against Justice Kanan of the Madras High Court came up. And he said that there might be problems, but let the system work. So why do we why are we holding the other two pillars totally unworthy of anything? Is that not unconstitutional at all?
See, the idea is not one body versus the other body, right? The idea is of essential checks and balances within those bodies. So, like, what you're doing in this case by allowing the executive to be a very, very prominent part of the appointment of very important people in the judiciary is making sure that the judiciary is left with nothing, right? So, my answer to your question of why are you not trusting the other two bodies is that because this move makes sure this body has nothing to do, right? It has no actual power and is always being like some way or the other meddled by the other two bodies, right? And that is the problem that we have.
Thank you. Yeah, we have a question for the proposition, so you can give me your comment with the answer as well.
I am Udayan Sanyal from Hidayatullah National Law University. My question has two parts. Firstly, various quasi-judicial bodies like Lokayukta, Human Rights Commission, Information Commissions are appointed majorly by the executive. But examples like Bengal Lokayukta hasn't been appointed for 7 years. Same was the case with Gujarat, Karnataka, Goa, UP. So won't putting the matter in executive's hand further aggravate the present problem? And second part is that won't bills like Judicial Standards and Accountability Bill or All India Judicial Services help solve the present problems better? Thank you.
What comes first, the cart or the horse? Yes, certain other situations will help the process further, no dispute. The second question is, please, can we have the record straight? The NJAC consists not of the Prime Minister. The NJAC consists not only of the Union Minister for Law. The NJAC consists of the following. Let's have the chapter clear. The Chief Justice of India, 2 senior judges of the Supreme Court, yes, the Union Minister for Law and Justice, and 2 eminent persons. Those 2 eminent persons are selected by who? That is the Prime Minister, the Leader of Opposition, and the Chief Justice of India. So everywhere you have not the executive appointment. It is not a question of meddling with the judiciary. It is what is called, and probably is correctly so, an independent judicial appointment system. Secondly, what Ira said. Ira said that the appointment system, if it is with the executive, it is meddling with the judges. And it is the job of appointment of judges is the prime job of the process of law, therefore it is bad. The judges' requirement is to dispense justice. The judge's job is not to appoint judges. Secondly, the tenure of judges is a fixed one in this country, 62 for the High Court, 65 for the Supreme Court. Once judges are appointed, by whichever process, assuming this one process or the other, they are there for good unless removed by impeachment, which never happens. So therefore, they have a fixed tenure, which is one of the highest hallmarks of independence of judiciary. Therefore, let us not equate the following. Appointment of justices is not equal to independence of judiciary. If we have that equation clear, I think we are home.
Thank you. A question for the opposition.
My question is for Mr. Akashya. I believe you have a grudge against the present government, which is fine by me. But I would like to ask you, the man who you particularly pointed out was acquitted in 2000 for the 2002 riots for the crimes which you have accused him of. And he was acquitted by the very same system which you hope to continue. What I want to ask you is, are you using or are you supporting the collegium just as a boot to throw at the present government? Or do you really believe in its virtues and its values? Or is it just...
Firstly, I'd like to clarify that the statement wasn't that I'm anti-Modi government or pro-Congress. The idea was essentially of politicization in general, right? Of course, if like that's been strawmanned into like it being just a grudge against the government, that's up to you. But the idea isn't that, right? The idea, and this is what Ms. Pinky Anand is trying to do, right? What they're trying to do is pretend like the NJEC is this independent commission, right? They're wanting to pretend like it is not affected by any politicization. All right, fine, like whether it's the Modi government or the Congress government, both these systems have vested interests, right? And I pointed out as well, right, that the Congress government will have vested interest in terms of like corruption and not intolerance, equally problematic. But coming back to this idea of politicization, you have one Chief Justice, you have two other judges. Along with that, you have the law minister and these two eminent persons who are elected by the leader of opposition, the prime minister, and the chief justice. In that equation, don't you see, firstly, in the election of these eminent persons, you have a majority of political actors in that scenario. These political actors have a vested interest, right? So, for example, a BJP and a Congress will both benefit from slightly lighter corruption laws, right? And they will both benefit from certain things that give the government or the executive more leeway, right? So they have that commonality of interest in terms of political systems. If you want to pretend and say that, no, I said this because I'm anti the Modi government or I hold a grudge against them, that's of course completely going strawman on that argument and like trying to get away with it. Just like Mrs. Pinky Anand is trying to pretend like this is this really independent commission that is made up of these nice people who are going to make this call, right? If you have two political actors in that scenario, further in the system of the NGEC itself, those 6 people, you have one law minister who has that vested interest of political fulfillment, and those other 2 eminent persons are people who are elected by a panel that is majoritarily political, and hence that reciprocity goes towards the political system and not towards the judiciary.
Thank you. We're out of time. We just have time for one question, which I'd like to ask Mr. Tulsi. You said you have a lot of faith in the people of the country, and fair enough. That is what democracy is all about. And philosophically, there is a rationale behind that. But to have them elect the judiciary, I just have a question. I see it hugely problematic, and you know, you've studied law long enough. An election, you know, there can be a certain mood in the country. There can be a certain way. We've seen that internationally, like you know, spoke about America. We've seen in Germany, we've seen in America, there is a certain surge because of certain short-term developments. Whereas the constitution was made by men who had thought through things, who were durdarshi, who had, and that will take primacy over any short-term knee-jerk reactions that the population may have. So when you go all the way and say it's a good idea for the people to elect the judiciary, don't you think that can be a hugely dangerous kind of scenario?
I don't think so. You see, I believe that the real issue is, how do we appoint the judges? The real issue is not who will appoint the judges. Unfortunately, how we will appoint the judges, the debate has just begun. Before that, there was hardly a debate. And how we appoint the judges is, my minimum is transparency. I am willing to accept the original intent of the Constitution as framed by the forefathers, but the original intent has been distorted. It's been turned into a football. It's become a turf war between the judiciary and the executive. The only way, according to my humble submission, is to break this logjam is that we talk about election. That's the most transparent method. Judiciary needs to be accountable. And they can only be made accountable. The first step is transparent mode of appointment of judges. I am appalled when it is said that law minister is the biggest litigant. No, he's not. He's not a litigant. He's only managing the litigation for the government. Why are we suspect of everyone who is outside the judicial system? The That's why the finance minister said that this is the tyranny of the unelected over the elected. We must uphold the greatest value of this constitution, and that is democracy. People are sovereign, and we must not undermine the system. I have immense faith in the people of this country.
Thank you. Okay, we're taking the vote now. So we have time for another couple of questions while the vote is taken. Yeah, it's for the opposition, right?
My question is directly to Mr. Bhattacharya. Sir, you accepted in your arguments that the Indian cabinet has the right to guide the president what to do. His advice shall be binding upon them. This is a written provision under Article 74 of the Constitution of India. You also stated that by default there is an exception under Article 124 as well as 217 where this advice is not binding. Sir, if such an exception were supposed to exist from the beginning, why is there not a non-obstante clause written therein that notwithstanding anything contained under 74, this shall be there? And if such a non-obstante clause is not there, does it not bring the two provisions in conflict with each other, where the same president who has to appoint the judges has to listen to the cabinet also, as well as the Chief Justice? So such an interpretation of the Constitution, do you not feel, is in fact bringing two provisions in conflict with each other and is not even harmonious construction, which is the basic principle of interpretation of the Constitution?
You see, it's like this. If the president is bound by the cabinet in appointment of judges, we won't be sitting here. And for 60 years, there won't be any debate. So, plain and simple, he's not. Number one. Otherwise, there won't be any conflict also. It will be beyond the fact that what advice the cabinet has tendered to the Council of Prime Minister will be beyond the pale of any judicial scrutiny. So, it's just not there. So, there is no dispute about that. The only question which can and should be raised, whether the President of India independently, in fact, in my respectful view, which I have also argued before the Supreme Court, because, you know, I was a petitioner in person. I filed a PIL. In fact, I was the second person to file this PIL. I have argued also whether the President of India can exercise his independent discretion, as which no president has so far done. But if President does it, in my view, there is a scope for President to exercise his independent discretion, which no President has done. So, the matter stands there. The executive, the Constitution as it stands for 65 years, from 26th of January 1950 to 13th of April 2015, this basic immutable structure is absolutely unaltered. President after consultation, and President not bound by the Union Cabinet after consultation. And in 99% of the cases, as Chief Justice Lodha has stated, even up to 1993, whatever after consultation, whatever Chief Justice has stated, President has simply signed. But a stage may well come tomorrow, and I hope it does come. It will further make our democracy vibrant, but certainly not executive and law minister. You see, I have been Additional Solicitor General of India, so has Mr. Tulsi. He knows better than me because he's much more sort of senior to me. Now, how a law minister manipulates litigation in the Supreme Court Central Agency, I have seen. In fact, I have written a book also. I have written a book. My experience with the Office of Additional Solicitor General of India, and that was, I was appointed during UPA regime.
We'd like to take one more question. Question is for those in favor of the proposition. And I repeat, could we have silence when the answer is taken, when the panel is answering? It's a basic courtesy we can extend to them. Thank you.
Hi, I'm Shrija. Anand ma'am, my question's for you. Ma'am, you're one of the members who's dealing with the collegium suggestions, and several suggestions have been made for improving the collegium, including making the proceedings transparent or bringing them under the RTI. But nothing like that had been even considered for the NJAC itself. So do you think that that would have been do you perceive that that would have been considered for the NJAC? Do you think so?
Absolutely right. Actually, NJAC remained like a stillborn child. Before the procedure of how it would function, how the process would take place, or the rules were framed thereunder, the entire issue of the NJAC Act itself became subject to judicial scrutiny and was struck down, so nothing else happened. The stillborn child finished at that. But while you remark on this part, you are right about the collegium process, and I must just make a statement here, because ultimately I spent hours, days on preparing the report to improve the collegium system. After having said whatever we did on the NJAC, it is a fact that one of the crucial issues which concerns us is transparency. One of the crucial issues which concerns us in this entire process of transparency is also the eligibility or the access, the right to access for all people, even trial court lawyers to become a Supreme Court judge, to be considered so. So all these suggestions have given us a very hearty feeling. Whatever it is, India moves on. If the NJSC has gone down right or wrong, this is where it is for the present point of time. But the fact remains that at least the glasnost and the perestroika that Justice Kurin Joseph talked about is on way. And that is the great part about this country. We never stop.
Thank you. We have a question for the opposition.
Hello, I am Anubhav. My question is to Akash sir. Sir, you mentioned Muslim and RSS. My question is that where does Muslim come in the appointment of judges, and why always a religious color is given to each and every topic of discussion? Thank you.
All right. I'm going to have to reiterate this again. But the idea of talking about politicization wasn't that, okay, so this example has been given, so the idea is that it's all going to become religious or it's going to be all become like corruption, etc. The idea was that politicization has with it certain problems. And these problems will come in the moment the appointment of these judges falls into the hands of the executive at some level, right?
I think you answered that question earlier. So, yeah, I mean, you can add another line, but he did address that earlier. But go ahead.
Yeah. All right. So I already addressed it, but the idea is that that statement wasn't to say that everything is religious or everything is political. The idea was that politicization in and of itself as a principle is bad with the judiciary, right? And these were simply certain examples that might come into play if you politicize this, right? So if you want to pretend like these things might not happen, that's very good for you. But when they happen in the future, then you can, I get to say I told you so.
Good afternoon to all. My name is Shubham. I have a very simple question for the proposition. Ma'am, opposition raised a very serious allegation of corruption. So what does NGAC suggest to tackle with the political corruption that might help to lead the debate further?
I'm sorry, you got it wrong. The argument of corruption was against the judicial appointments, against the judges, which includes people like Justice Ruma Pal, which includes Shanti Bhushan, which includes instances reported in court. This is not my statement, this is a statement on record which is there, that there is a number of corrupt judges who were sought to be appointed. There is some corruption in the judiciary. Definitely not my statement alone.
No, I'm not saying. I'm saying the proposition has been alleged for that. So what are the anti-measures for that?
Again, that process of having an independent judicial commission was to actually have a system which counter-checked each other and outweighed each other to ensure that there was transparency in the system, if possible, and that would come later as a step to evolve. But in addition, you kept checks and balances so that you'd have the appointment of the best. The idea was to have the best appointments in the judicial appointments.
Yeah. Okay, we have one for the opposition now.
This is Ankitesh Oja from HNLU. My question is to Ira ma'am, because she pointed out the corruption thing. We all know that this complete separation of power is not possible anywhere in the world. Many countries have tried it, but it didn't work. So don't you think that giving absolute power to one body, that is judiciary, will make the chances of corruption very high?
We again need to come back to the Indian context, right? We can't talk in the air and say, well, you know, perhaps just the judiciary is going to be more corrupt, or maybe just the executive is going to be more corrupt, right? Let's look at the current scenario right now, right? What does the public think? Who does the public think is more corrupt? Who does the public trust less, right? Is India a country where, let's say, we're all young people, right? How many of us aspire to become politicians, right? How many of us like dream of saying that, you know, I'm going to be like a very great politician or something like that, right? How many of us every day hear that politics is not something that you should get into, or it's sort of going to change you even if you want to change the system and things like that, right? So we need to look at what is the current scenario, right? What we are saying is that the moment you put in people that the public doesn't really like trust with, right? And that's what Akash was trying to say when he gave that example of, if I am a Muslim and I want to go and file a case, right? I'm going to be very apprehensive, right? Because I don't trust the current government, right? But the judiciary is something that stays independent of all of this, and that's why I have the courage in myself to go and file a case, right? And that's what we're saying, right? The moment you sort of mix these two, I will not have the faith to go to the judiciary as well, right? So who do I go to then, right? So this is the only idea is of securing that particular thing for the especially for the minority, right? Because the other body is anyway majoritarian. So it's important to make sure that there is a body that is not actively biased with this majority, and that was the entire idea behind that motion.
We have a question from Ms. Jain.
I have a response to.
Yeah. After Ms. Jain, you can respond to that as well.
Okay, so my question is that can we not segregate these eminent personalities? There was a lot of talk about how these eminent personalities need to be part of the decision panel so that we have an outside opinion on the judiciary as well, and it's not just, you know, an independent, isolated judiciary body which elects the Chief Justice. But, you know, okay, like taking a very crude example, it's like asking a lawyer to select the chief neurosurgeon of a hospital, or it's like asking you know, people from different fields to interfere. Why can we not have eminent people of the judiciary department in charge of selecting the Chief Justice and eminent people of other departments in charge of selecting, you know, other fields? Why does there have to be an amalgamation?
There's no disqualification for legal eminent persons. Eminent persons is an inclusive statement, A. And B, there's nothing on the record to suggest that if you had defined eligibility criteria, assessment could not be done by independent eminent people. There's no evidence to show that. So therefore, to say this, if for example you have a grading system for selection of judges, you had an open invitation for people to apply to become judges, and if you had an independent panel to say, here's the grade, he's not a lawyer, he's sitting here as the moderator. Nonetheless, he seems to have gained enough knowledge of the subject one way or the other. So he's sitting there. So you can assess. You have a non-lawyer here who is debating against the proposition. So it is impossible to say that you cannot have an assessment by an independent agency of a particular category just because you are not an expert in the field. That's one part of it. Secondly, as I said, you could have even lawyers who are eminent persons. And thirdly, yes, there would be broader discussions on that, but only on that ground you can't disinherit the system to say you have eminent persons. There is a possibility that they are political appointees. There's a possibility that one of them will be gay, so therefore throw it out. That's a ridiculous kind of proposition.
And you had a rebut to...
Yes, you're right, but I forgot.
Okay, would Ms. Jain like to add to that?
I was going to say exactly what Dr. Anand said, that there's absolutely no disqualification of legal persons to be eminent persons. And if you look into the judgment text of the NGAC case, you'll see that a lot of lawyers did advocate, in fact, that there should be people from the legal field who are selected from the very top layer of the legal field to be these eminent persons. But another important aspect is, even if they aren't people from legal backgrounds, it's important to note that we're not just electing lawyers as judges, and their only role isn't to dispense of the law or to be very able with the law. That they're, at the end of the day, government officials who have to dispense justice, and there's a lot more that goes into selecting a judge than merely his merit when it comes to the law. And that's why even ordinary citizens who are of great integrity or who are eminent persons in even another field would be able to offer valuable perspective in choosing persons who aren't just good at what they do, but are even persons who are seen to have integrity or the right to hold that high judicial office.
Thank you, Ms. Jain. We're out of time. I believe the rapporteur has something to say before I announce the results of which way this House thinks.
Thank you, sir.
We are honoured today to have amongst us Mr. Virendra Sharma, MP United Kingdom and Chairman, Indo-Bar All-Party Parliamentary Board. Mr. Nachiket Joshi, Convener, United Kingdom INBA. Mr. Kaviraj Singh, Secretary General, INBA. Mr. Kumar Rajesh, Senior Journalist.
Thank you for that. We've had a wonderful debate, and I thank all the speakers for educating us and making us more aware than we were before. Before the debate started, we took a vote of the House, and those in favor of the proposition that the NJAC should replace the collegium were 54, and those opposed to it were 52. After the debate, those in favor of the proposition are 55, and those in favor of the opposition are 51. So you have changed one person's mind. So clearly people have dug their heels in on this. On that note, I'd like to thank all of you. I'd like to thank everybody who attended for being a wonderful audience. I'm sorry I couldn't take so many more questions that people wanted to ask. Now I hand over to the repertoire if there's anything else you want to add. Thank you all. And yeah, I'd just like to request the panelists to stay on the stage. They need a group photograph before you alight the stage and everybody mobs you. So could I just... Yeah, sure.
You should have the best debater award. I would give it to Akash.
All right. Well done, Akash. Okay, thank you. Like I said, could you just have you on the stage? We need a photograph.
We'll have the vote of thanks now.
It is a privilege and an honor to propose a vote of thanks on this occasion of the maiden Indian Union debate on behalf of the Indian Union Debate Forum. May I first convey a heartfelt thank you to everyone present who has contributed to making this occasion a success. Foremost, the eminent speakers. Our deep gratitude to each of you for sharing your views with us and also for the invigorating interactions during the question and answer session. Our appreciation to Mr. KTS Tulsi, Dr. Pinky Anand, Mr. Bishwajit Bhattacharya, Mr. Akash Patanayak, Ms. Isha Jain, Ms. Ira Regmi, and Mr. Abhinandan Sekri, who has chaired the debate. We also thank our supporting partners, the Section for Law Students of the Indian National Bar Association, who have extended their full-fledged support to this event. We are grateful to our sponsors, Mr. Navroz Shirvai and Mr. Siddharth Luthra, who extended their invaluable support to this initiative. We have been fortunate enough to be backed by a team of motivated and dedicated volunteers, without whom this event would not have been organized. Lastly, I thank the audience, all of whom have played an instrumental role in making this event a success. Thank you. I request the audience to please exit the venue through that door and that exit, and I request the dignitaries to please remain on stage. Thank you.
If you enjoyed that, click up here to support us and down here to subscribe. Be sure to check out our older episodes and the other stuff we do, like Can You Take It, I Agree, panel discussions, comics and animations, and much, much more.